Hello students and a very warm welcome. Today I am going to be discussing the most important fundamental right that has been enshrined in part 3 of the Indian Constitution, and that is Article 21. Article 21 guarantees to us a right to life and personal liberty. Now let us begin this session by reading what this article is all about. The text says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now let us analyze the text of this article. So first of all, what it is doing is it is preventing encroachment on personal liberty. The second thing that it is doing is it is preventing deprivation of life, and it is protecting both our life and personal liberty by ensuring that the only way in which anyone can interfere with your life or personal liberty is procedure established by law. And students, the concept of procedure established by law has been adopted by the Indian constitution makers from the Japanese constitution. Let's move further. Now, why is this article relevant? What we have to understand is that all the other fundamental rights are going to be meaningless if we do not ensure this right to the people within the territory of India. And that is why it's very important to understand that this right is available not only to the citizens of India but also to the non-citizens. So this very concept can explain to us really well how fundamentally important this article is. Let us quote Justice Bhagwati and let's see what he had to say about the sanctity of this article. So he says, Article 21 embodies the constitutional value of supreme importance in a democratic society. So from this very quote we can understand really well how important this article is, because this article is the most basic article, and every other fundamental right, constitutional right or legal right can only add some value to this right, and in the absence of this right all other rights are going to be meaningless. Another outstanding feature about this article happens to be that it is one of the most organic and progressive provisions that we have. When I say organic, I would say like a living organism. It has evolved, it has grown, and the very next word on this point supplements the idea of being organic, because it has progressed with the changing times. This article has really responded to the changing needs and demands of an individual's life. As I've already mentioned, this slide tells us that it is also available to citizens and non-citizens, and it will make every other right's availability meaningless. Now, who is this right available against? The first question that this slide puts to us is it available against state action? I would say definitely. It is available against state action. If a private individual encroaches upon our personal liberty, will this article come into play? I would say no. If a private individual tries to interfere with your personal liberty or your life, in that case Article 21 cannot be invoked. Finally, the third question that we are being asked is if the act of the private individual was supported by state. In that case, I would say definitely Article 21 will come into the picture. So wherever there is state involvement, whether it's partial or it's complete and it encroaches upon your right to life and personal liberty, you can most definitely invoke the writ jurisdiction of the Supreme Court and High Court under Article 226 and Article 32. So finally, we can conclude that it is available against state action, but not only. Even if the state is partially involved, we can invoke this article. Now, state action. Article 12 basically defines what state is. Now, if you take a look at this slide, it is giving us the definition of who all are within the definition of state under Article 12. First of all, Government of India and Parliament. When I say Government of India, I am including the President, the Prime Minister, the Council of Ministers. The Parliament, of course, involves in its definition the Lok Sabha and the Rajya Sabha. If we talk about government of a state and legislature, again we are talking about the chief minister, the council of ministers at the state level, the legislative assembly and the legislative council, and of course the governor. The third point is talking about local authorities within the territory of India, and those would be municipalities or village panchayats and port commissioners. And finally, we're talking about authorities which are local in nature, which may be within India or which may be outside the territory of India. Now, what is the scope of Article 21? So, Article 21 is ensuring to anyone who is within the territory of India something much more than a mere animal existence. And Article 21 is trying to ensure all those core concepts to us, which are very essential for a meaningful, complete, and a life that's worth living. And it is basically ensuring to us those unavoidable, basic, and necessary necessities without which the holistic development of a human being is completely impossible. Now, Article 21 and the way it's been interpreted and expanded, it happens to be the biggest example of not just judicial activism but also judicial creativity. Now, when I talk about judicial activism, we've borrowed this concept, of course, from the American Constitution, but what we have to know is that judicial activism is when judiciary as an organ of the government can place a check on the actions of not just the executive but also the legislature. So in a way it is keeping an eye on overstepping of jurisdiction in case of executive as well as legislature. Judicial creativity, I would say, is when judges are reading their own interpretations into a law and they are giving us judge-made laws. So they are going outside their limitation of simply adjudicating upon laws, but through their own personal opinions and ideas on a certain issue, they are giving us certain guidelines which have the value of law and which has been aptly termed by Durkheim, the eminent jurist, as judge-made law. Expansion of Article 21. Now, the way this article has been interpreted time and again has made Article 21 one of the most widely interpreted and I would say most beautifully interpreted article in the Constitution, and where judges from time to time have included the most basic things, the most fundamental of needs of an individual within the periphery of this article. Now, it was very specifically told to us by the text of Article 21 that we can only be deprived of our life and personal liberty by the procedure established by law. It's very important that this procedure is just, fair and reasonable, and this fact was also reiterated in the case of Menaka Gandhi versus Union of India, and they said that the process of deprivation of a person's life and personal liberty cannot be arbitrary, unfair or unreasonable. If you look at the next case on the slide, it talks about CERC versus Union of India, and it says that right to live with human dignity is very, very imperative to the right to life mentioned under Article 21. Ram Leela Maidan is a fairly recent judgment of the Supreme Court which has included the right to sleep within the ambit of right to life under Article 21. The next slide discusses two more cases, and People's Union for Civil Liberties versus Union of India has included the right to privacy within the meaning of Article 21. The next case talks about Selvi versus State of Karnataka and how mental privacy was also included within the definition of Article 21, and where brain mapping tests, polygraph tests, narcoanalysis tests were considered to be unconstitutional and in direct conflict with Article 21 and Article 20, Clause 3, which talks about self-incrimination. The next slide talks about Olga Tellis versus Bombay Municipal Corporation, and in this case it was laid down that a right to earn your livelihood is very important if you want to guarantee a person his or her right to life. The next case on the slide, Parmanand Katara versus Union of India, they said doctors are going to be under the moral obligation to treat their patients irrespective of all circumstances. So by virtue of certain cases over the period of time, the courts have done away with the concept and criteria of completing police formalities before treating a patient. Expansion of Article 21 has been done to the extent where prevention of sexual harassment at workplace was also interpreted within the purview of Article 21, and Vishakha versus State of Rajasthan happens to be one of the most glaring examples of not just the concept of precedents under Article 141 but also of judge-made laws, because it was a judgment that came out in the year 1999 and it laid down certain guidelines for the prevention of sexual harassment of women at workplace. And right from the time period of 1999 up till 2013, we did not have a legislation prohibiting sexual harassment at workplace. And between this time frame of 1999 and 2013, Vishakha versus State of Rajasthan continued to carry the value of law as far as dealing with cases related to sexual harassment at workplace was concerned. Then something as minor or something we would totally miss out on is access to roads was also interpreted within the meaning of Article 21. Finally, MC Mehta versus Union of India was a public interest litigation, and basically the Supreme Court laid down that we have a right to a clean and safe environment if we want to ensure the people their right to life. Now, the antithesis of right to life would be right to die. So, in the case of Gyan Kaur versus State of Punjab, they very clearly laid down that suicide is an unnatural termination or extinction of life, and it cannot be compatible with right to life. So, right to die does not flow from right to life. Then, how is the concept of euthanasia different from right to die? Now, euthanasia is a way of respectfully allowing a person who is in a permanently vegetative state to die with dignity. But right to die is when you spontaneously cut the flow of life, you bring your course of life to an unnatural halt, and that is why in the case of Gyan Kaur versus State of Punjab, they were categorically separated from one another. Also, the Indian Constitution and the Indian judiciary values the life of an individual, and that is why they have come up with the concept of awarding death sentence in the rarest of rare cases, because deprivation of life according to a procedure established by law can only take place when the judiciary or the law allows it, and that also can only be done in the rarest of rare cases, as this theory has been devised by the Indian judiciary to ensure that people are not sent to the gallows until and unless it happens to be a rare case where there is no chance of reformation and an exemplary punishment has to be set out for the rest of the society. And I'm going to wind up this session by discussing Aruna Shanbag case. In this case, a nurse who had been in a vegetative state, in a brain dead state for 42 years after she was raped and assaulted by a ward boy in the hospital where she had worked as a nurse. And as per this case, the Supreme Court in a very landmark judgment said that India in the coming time may be open to the idea of passive euthanasia. Passive euthanasia is where you stop giving the patient who is in a permanent vegetative state any medicine or any active life support. That is passive euthanasia. But active euthanasia is something that India has not accepted, which means injecting lethal substances into the body of the individual who is in a state of being a vegetable. And that is how India has differentiated between active euthanasia and passive euthanasia. To conclude this session, I would say that Article 21 and the way the Supreme Court, the High Courts have gone beyond the legislative intent, and they have expanded the meaning of this really concisely worded article beautifully, has gone a long way in changing the face of Indian jurisprudence. Thank you so much for your time.